friend of the show here. Thank you so much for taking the time to join us.
Thanks for having me. An interesting day we're having today with Bryan Kohberger getting indicted by the grand jury. And now we're going to see this trial move forward and see if they have the evidence to prove he killed these four college students.
Was it a surprise to hear that an indictment had actually been handed up here? Because we know that, they have the option of a grand jury or that preliminary hearing, which had been set for next month. It's been talked about for so many months here. Was that surprising to hear that now, out of the blue, he's indicted?
We have to remember that each state has its own rules on how it does things. And in Idaho, they have this criminal rule 5.1, which seems pretty funky to other places. And in Idaho, they have this choice. You can convene a grand jury, you get 16 jurors, 12 of them have to agree, and they have to hear the evidence, only one-sided evidence, only from the prosecutor, and decide if there's reasonable suspicion of guilt. That doesn't mean he's guilty, that just means that there's evidence there that says we need to go prosecute this. There's an alternative route, which we thought was happening, which was this preliminary hearing. They don't need a grand jury in Idaho, but the judge has to, within 14 and 21 days of their first arrest and coming in, they have to have a hearing where the judge would determine if there's reasonable cause. I personally am happy that a case of this magnitude went to a jury of his peers, the grand jury, as opposed to a standalone judge. It shows more legitimacy moving forward on a case with national attention.
And there was set to be some testimony here at the preliminary hearing when that was scheduled to happen for next month. So does that mean we won't get more information here? We were expecting to possibly get some new details during that hearing. At this point, is it possible that we're just not going to get that information now?
Yeah, so there's two things happening now. First, we're going to get information on the 22nd. That's just around the bend, because that's the date we're hearing he's going to get arraigned. When we say new information, though, at an arraignment, most people just come in and say very little. An attorney generally will make an appearance, waive the public reading, meaning we don't need to hear the charges. We know what they are, and enter a plea of not guilty. They'll usually do something that says they're ready, which puts the prosecutor on a time crunch, as we have rights to speedy trials. And that's really all we get. But what's more interesting, and this is the part I want you to focus back on May 5th, there was a motion from the defense team saying, I want all the footage of getting all this records on how he was arrested and all the evidence, because you see the defense is starting to point out there may be a DNA issue, because that's how they tied him to this murder. And we're going to have to find out more, because the evidence is going to be the key moving forward. And unfortunately, I think we're going to have to wait a little while till we find out something there.
What happens next in the legal process now that we know that he has been indicted and he will be arraigned there on Monday?
Yeah, so the first step is this arraignment again. The arraignment means that he's going to plead not guilty. The judge can hold him on in jail. They could just say, we're not releasing you. You're a flight risk. That's a possibility. And just to remind you, this is a guy who fled to Pennsylvania, his family home, when they found him in the first place. So they can hold him that way. They can also let him out. They can also have bail terms. That's something that could go down on this hearing that we're seeing on the on the Monday coming up on the 22nd. And then from there, we're going to see much more of this motion practice. That's called an application. A motion just means you're asking the judge for some sort of relief. And we're going to see a lot of disputes going on whether evidence gets in, whether evidence was tainted, because this case all comes down to that DNA evidence. And if it wasn't collected properly, if it wasn't compared properly, even if he's guilty, they're going to have a lot of problems proving beyond a reasonable doubt that he killed these people and should be tried on first-degree murder, which is what they're pursuing, which results potentially in a death penalty. This is some serious stuff.
And I know that each case is pretty much its own beast, so to speak, but is there any way to know how long it would take for a case like this to go to trial if it does actually go to trial?
I want to loop back to something I said before. There's a very big difference between a civil case and a criminal case. In just going to the Constitution, we understand that criminals can't be held without a trial forever and ever and ever and ever. We understand that. And that's why there's a right to a criminal defendant to have a speedy trial. So as soon as they say, hey, we're ready to have a trial, the defense could do that at any time, and the prosecutor's got to jump and go. I'm not thinking it's going to be yesterday that we're having a trial, because we have these evidentiary issues. We have these suppression issues. And the people, interesting, the prosecutor said, hey, we don't have any body cam footage when the defense made that motion. And that's a curious thing. Why don't they have cameras recording their collection of evidence when we're dealing with such an important situation, when they went to the family home and they got that evidence? So I don't see it happening tomorrow. I don't see it happening yesterday, obviously. But I would say in the coming months, we're going to be seeing a trial here, and it's going to be a very interesting, best show in town.
And is there a chance that this actually never goes to trial? Could there be a plea agreement at some point prior to a trial ever taking place?
Yeah, there's two possibilities. Number one possibility is we could have the key evidence suppressed. It's possible. This happens in any criminal case. The defense counsel could find flaws in the collection of evidence. Search and seizure, we've probably heard about that, how we have a right in the Constitution. If the people did improper searches, improper seizures, and that was what they based their whole evidence on. We've probably seen a Law and Order episode where they say, people, you have another day to fix this, otherwise we're dismissing this. That's one way that it could go down. The other way is, as you alluded to, there could be a plea bargain, a settlement. Why would that happen? Well, you see, he's facing the death penalty. So it's very possible someone facing the death penalty could say, you know what, I did it, but give me life in prison. I don't want to die. That's a possibility. At this stage, though, on Monday, when we're dealing with this arraignment, I don't see that happening yet. We're going to have to see some of these preliminary motions shaking out before both sides understand their true risk assessment. And only after understanding your true risk assessment can you make smart dealings to try and do a plea agreement.
And the arraignment itself is pretty much going to be the same, I guess, as any arraignment. There's going to be no difference. I imagine it's going to be a fairly quick hearing. He enters that plea of not guilty, assuming that's what he does, and that's pretty much it, right?
An arraignment's a whole lot of nothing. It's one of the things that most criminal defendants don't like, but most partners in law firms would be perfectly happy to send a first-year associate to. So the only reason why a partner is going, or someone good in a law firm, is to have an appearance and FaceTime with your client. But really, you could be slightly non-functioning and do an arraignment. It's a robotic type of experience. You say, hi, my name is such and such. I'm from such and such firm with such and such address. I waive the public reading and I enter a plea of not guilty, and then you're done.
All right, I'm going to ask you a very loaded question that I know we've talked about before, but why do you think people are paying such close attention to this case as it does develop? You have so many people that are following it every step of the way. Why is that?
My PR and social media team probably wants the answer to that question too. I wish I could understand the pulse of the people. I'm going to tell you what I'm seeing, because I like to read social media on both sides of the political spectrum. I think that's very important, with the really charged people on both sides. And I think one of the big issues is twofold. Number one, college students. We all relate to college students. I think college students are interesting. And when I say relate, even if we didn't go to college, they're kids, they're in their 20s. These are babies. These are people we're all caring about. And it's one of those stories where you see, wow. But the more interesting part for me is that this defendant was a criminology major. He's studying criminology and he gets caught with DNA evidence. The irony of that, and him not covering his trails and fleeing to Pennsylvania, I think there's just juicy drama there. And if this was not real, which is terrible, I just have to put that out. Terrible what happened. Terrible that these 4 students are dead. Terrible, terrible, terrible. Whoever actually did this, whether it's him or someone else, should definitely face charges and definitely have serious punishment. That all said, assuming it was fake, this would be one of the best TV shows ever, that a criminology major is a defense in a murder trial. It's just made for TV movie. So I think that's what's got the public all wrapped up in it.
And we talked about this a short time ago, but this is technically a death penalty case, correct? That is an option here.
It's an option, and I could definitely see it happening if they could tie him 100% lock and sinker to this case. This is, again, something that people can touch and feel, and unfortunately or fortunately, we're emotional creatures. We as humans have emotion. We feel things, and when you're killing 4 kids, that's something that most people say, kill them. And I have to tell you, it's scary because we find DNA evidence sometimes is flawed, and we find sometimes DNA evidence changes as technology changes in the future, and the death penalty is a real final thing. So there's going to be people that are for or against the death penalty, but assuming the death penalty is on the table, which it is in Idaho, I could definitely see that being a result, and I could definitely see that be a reason for him taking a plea bargain. I think that's why we're going to see plea bargain negotiations, assuming these suppression motions fail.
And another big question here, how hard is it going to be to seat a jury in this case, people who haven't heard about the case, considering how much national attention it has received?
Well, I'm sure they'll have heard of the case. I think the real question is, are they biased when they heard of the case? And I think the word biased has become problematic based on how people are hearing it. We just say the word biased in the media. Bias doesn't mean that you don't think that people that did crimes or he might have done crimes or what. Bias means that you can't listen to the instructions of the court and follow the rules moving forward. You see, you have to be able to separate who you are, what you know, from what you're hearing in the evidence and what the instructions of the judge are. And it takes a lot to make a juror biased. And I don't see anyone having major issues. Like if it was maybe his cousin that was on the jury, that would be a problem. But someone that's watching you on TV, which I know the whole nation should be doing right now, is that person's not necessarily biased, and that doesn't taint the jury pool.
All right, Andrew Lieb there with Lieb at Law. Thank you so much, as always, for taking the time to join us on short notice and help break down these breaking news stories. Anything else you want to add about this case or anything else before I let you go?
I think that we have to look at it two different ways. One way we have to look at the case is it's a juicy drama with this criminologist major who is going after and getting charged. The second one we have to say is, do we want unreasonable search and seizures of us? And to the extent that evidence was collected unfairly, and I don't know that to be true, but to the extent that happens, we want to preserve our constitutional rights from unreasonable search and seizure. That's what makes our system great, that defendants and the prosecution have rights.
All right, Andrew Lieb, thank you again for taking the time here to join us. We appreciate it.
Thank you.